All right. So I'm here today with a guest speaker, and we're doing a quick preparation video for our upcoming MBA course. So I'm super thrilled to have Brian Rosenthal with us here today. And before we sort of head into this quick overview of Brian's work and his legal practice, I of course want to say that nothing that we say in this video, in our short conversation here, is meant to be advice of any kind, legal or otherwise. So Brian Rosenthal is currently an attorney and equity partner with Loria, Tokunaga, Gates, and Lynn. And Brian practices civil litigation where he has a significant experience, including jury trials. So Brian, my first simple question to you is just, can you share a little bit of your background and your legal practice with us?
Sure, Jessica. Yeah, thank you. I'm happy to do that. And I also appreciate the disclaimer at the beginning that this is not to be construed as legal advice, especially from lawyer that I am. But yes, let me tell you all a little bit about my background. I'm originally from Sacramento, Jesuit high school graduate here in Sacramento. Then I went down to UCLA for undergrad, graduated with a history degree from there. Then I decided to go to Santa Clara University School of Law. After graduating from Santa Clara, I then furthered my education quite a years later because I got more interested in some business things and got an MBA from the executive program at Sac State. My legal experience right after law school was in the US Navy first. It was as a JAG Corps officer, where I had accepted a commission while I was in law school, and I was a lieutenant in the US Navy. Maybe some of you have seen A Few Good Men, Tom Cruise, a little bit like that, but it wasn't quite as cool as that. Anyway, in the Navy, my practice was mostly court-martial criminal defense, where I would defend service members when they were accused of various crimes, and the crimes could be civilian type crimes like assault or drug distributions, or they could be more military specific type crimes like mishandling of C4 explosives or something like that. So that was what I was mainly doing in the Navy for 4 years after law school, and also did some administrative discharge type hearings where I would defend service members when the military was trying to get them discharged from the military. So it was a sort of an employment hearing kind of thing. So that's what I started my legal career, and I'm doing a lot of criminal work. After fulfilling my obligation in the Navy in 2005, I came back to Sacramento, started work at a firm named Schuring, Zimmerman and Doyle, which was mostly doing medical malpractice defense, defending physicians and hospitals, other healthcare providers in litigation brought against them usually by patients. I did that through 2008. In 2008 is when I joined my current firm, which is Loria, Tokunaga, Gates, and Lynn, and I've now been here since 2008, then making equity partner in 2014. So I've now been here at this firm quite a long time. My practice here at Loria, Tokunaga, Gates, and Lynn is a little bit more varied than what it was at the Schuring firm. It's doing a lot of medical malpractice defense, like we did at Schuring, defending doctors, hospitals, skilled nursing facilities, and then also other types of defense work, such as premises liability. Somebody slips and falls at a grocery store and sues the grocery store. I might defend the grocery store. Or also auto accidents. I might defend the drivers in an auto accident case. And also every once in a while I would do a plaintiff's case where you're actually the one bringing the lawsuit against a party, but 95% of the time I'm on the defense side of litigation. So that's where I'm at. In my practice, we generally go to trial a lot more than other law firms, and that's in large part in the medical malpractice arena, because the doctors have to agree to any sort of settlement. Even if the doctor has an insurance company that's paying their bills or paying my bills or paying any settlement, it's still up to the doctor whether we want to settle a case. So that and causes in part a lot of cases to go to trial, because there's a lot of times doctors don't want to settle a case. I mean, one, the firm belief that they didn't do anything wrong. We've had experts review the case, didn't believe they did anything wrong. They don't want any sort of medical board issue. There's a lot of reasons why these cases go to trial. So I think it's given me, which I think is fortunate, and sometimes I feel unfortunate because of the workload it requires, but we've gone to trial more than what a lot of other law firms do. So that's kind of the little bit of background about my experience.
Thank you for sharing. And yes, I had the good fortune of having you in the or meeting you in the executive MBA program. So you have a quite varied background and been exposed to a lot of different types of environments with your law and different types of practices. And so we probably don't have time for all of that today. But my first question would be, how do you manage mediations and settlement negotiations when there is an ongoing lawsuit between parties?
Yes, and mediations certainly is a big part of our practice. And I think in the law in general, mediations have become much more popular in recent years, where there's a lot of people that specialize in mediating cases and trying to help work the parties to resolve the case. But my initial thought on mediation is, before we even get to mediation, we of course need to do a lot of just factual analysis of the case, where we're doing a lot of discovery, learning about the strengths and weaknesses of our case, learning about the other, what all could potentially happen at trial. Because I think that before we even get to the mediation point, we've had to do some workup on the case to determine what the strengths and the weaknesses are, what the potential exposure is. And so generally that's part one, is having a good amount of workup before a case. I mean, sometimes there's a little bit of an exceptions to that. If a case we know is really bad and their demand that they made is very reasonable, we might just settle a case really quickly. But generally that's one of the biggest things that I like to do, is just do a lot of workup before we get to that mediation or settlement negotiation phase.
Would you say that anything in that sort of workup phase before mediation, right? So we are here to, talk to a group of MBA students, right? And they come from different industries with different backgrounds, government, for profit, right? Is there anything us as lay people, not attorneys, could take from that workup process and apply? There might not be. I just thought of the question.
Sure, and I think that whenever there's something that is in dispute, you want to be thinking about what are the objectives of what we're trying to do in resolving this dispute, and thinking about what strengths that you could present to the other side to try to convey your point. And I think that it's certainly important that there's compromise, and I know we can talk about that more, about managing expectations and the like, but I think it's just analyzing the facts of the dispute, regardless of whether it's in the legal context or some other context. There's always facts in a dispute, even if there's no lawsuit, even if there's nothing legal about it. There's just, one side has these things that are pros and cons, and the other side has these things that are pros and cons.
Super. So a significant challenge is dealing with the opposing side during a dispute. What would you recommend for how to resolve such a dispute or dealing with that opposing side, apart from what you just shared?
Right. One thing I would say is, in dealing with the opposing side, don't just analyze the strengths and weaknesses of the opposing side's case, but also try to think of what are the emotions that are driving the opposing side to try to get a resolution, and be cognizant of that. For example, if it's a case where a neighbor is suing a neighbor, and neighbors have lived next to each other for a long time, and they've had ongoing issues, and it's and years of potentially emotional baggage between the two of them. Even if this lawsuit is just about a fence, you got to be cognizant of the fact that this neighbor brings to the table these negative emotions that have happened over the years. So I think that sometimes if you want to try to resolve the case, you've got to be sensitive to that, and don't just be a kind of a Rambo litigator saying, we need to go trial, we're going to win this case, and try to work with them saying like, hey, we want to be reasonable, we want to come fair, we understand that there's been differences in the past, because sometimes if you're just too aggressive with the other side, just based on the strengths of your case, you might not be able to get the case resolved because that other side may have such emotional attachments to things that have happened previously.
Do you take coursework on how to manage emotions and expectations in law school?
No, but that would probably be a good idea, certainly. I know that after law school, there's sometimes continuing legal education courses about negotiations training, but at least when I was in law school, there wasn't taught those classes. It was much more just law topics, constitutional law, criminal law. And I always kind of joke with people that maybe law school teaches you in part some about some of the subjects, but it doesn't really teach you that much about how to be an actual practicing lawyer as much. It more teaches you how to start to think like a lawyer in some ways.
Right. And I do some work, outside of the college with, sometimes a healthcare organization. It's the same thing, right? With the medical practitioners. It's all about how you, execute, medical treatment and, diagnose. And there's nothing about the bedside manner and,
Right.
but it's good. People like me will have jobs for forever.
Right. And I also noticed, speaking of that, sometimes I think a complaint about sometimes younger lawyers is they're just too overly aggressive is one of the issues that we see, that people come right out of law school and they just think it's time to just go to war, or basically, where it ends up not being the best results for their clients, I think sometimes when they're overly aggressive. So I think that is something that after doing it for a while, you start to realize that we can get the best resolutions for our clients when we're very respectful of the other side, treat them dignity, try to hear where they're coming from. And, you can still be a zealous advocate for your client, but you are, keeping the other side's perspective in your mind when you're trying to negotiate with them.
Wonderful advice. So I only have, one little question left, maybe not little, but so we've been talking about, sort of emotions and managing expectations. And so, and you've spoken to it already, I think a little bit, but how does this actually help us negotiate more in good faith? And I think you've spoken to that a little bit, but if there's something you would add to that to find resolution.
Right. I mean, I think we've already talked about how you want to be managing it, negotiating in good faith, certainly with the other side. And even with your own client, there's a lot of, I don't know if I'd call it good faith negotiation, but good faith discussions with your own client and trying to see also where your own client is coming from and really trying to manage their emotions as well. Because, we sometimes have a situation where a doctor believes, sometimes very justifiably, that they did absolutely nothing wrong, and they're so upset about the case, and the idea of ever paying any money upsets them. So sometimes we have to spend a lot of time just with our own clients and tell them, look, that it's unfortunate that you're going through this, but we will get you through the process. We will, vigorously defend this case. But if it's a situation where we've had experts review the case and expert after expert has said that this is a case that has some problems, we got to have those good faith discussions with our own clients and say, look, I understand that you believe that you did everything right, but here's XYZ potential problems, and maybe we want to consider a small resolution of the case. But on the flip side, and quite often in our practice, that it's a situation where a patient had a complication for a procedure and the procedure didn't go as they had hoped. But a lot of times, in the majority of times, in my view, granted I'm on the defense side, but in my view, that the care was totally appropriate. So just our good faith is more just saying, sorry, but we have to either go to trial on the case, because sometimes the cases can't resolve by negotiations if the patient is unwilling to drop the lawsuit and we're unwilling to pay settlement on a case.
Yeah, thank you. And so what I hear here with you here is also, that communication and perspective taking with your clients, right? So all around, just that transparency. And as you started talking about here, in terms of sort of fact finding and finding what is going on and strengths and weaknesses, right? So a lot of that work occurring on your own side as well.
Correct. Correct.
Wonderful. Well, we certainly look forward to having a conversation with you in the classroom. So I hope this helps our students set us up for that success. And I thank you so much for your time today. And I look forward to seeing you shortly.
Oh, thank you very much. My pleasure.
Thank you, Brian. Bye.